Hello friends, in the series on the income tax cases, today we will discuss the case of Joint Commissioner of Income Tax versus BHILAI Engineering Corporation Limited. This case has been reported in 454 ITR at page number 540. The matter has been decided by Supreme Court and the date of the judgment is 1st May 2023. The purpose of discussing this case is that whenever there is a question whether the assessee has made the bogus purchases or not, when this matter has been decided by the ITAT that the purchases are not bogus, or inversely, if the ITAT has decided that the purchases are bogus, so whether these purchases are bogus or not is a question of fact or a substantial question of law. This was the moot question in this appeal before the Supreme Court. In this case, the Income Tax Department received the information from the Maharashtra Sales Tax Department that the assessee has made bogus purchases. When this information was received, the assessing officer completed the assessment by making the addition on the basis of the bogus purchases. The assessing officer applied section 145 subsection 3 by rejecting the books of accounts of the assessee and made the best judgment assessment under section 144. There are some conditions in section 145 subsection 3 in which the books of accounts of the assessee can be rejected. At the same time, the learned assessing officer relied upon the celebrated judgment of McDonald Company Limited versus Commercial Tax Officer, which is a very old judgment of 1985 and which has been reported in 154 at page number 148. In that case, the Supreme Court had said that the tax planning can be done if it is within the four corners of the law. But if the assessee adopts some malpractices to evade the tax, then it is not allowed. So the assessing officer, relying on this judgment, tried to drag the assessee into the facts of this case and held the purchases as bogus. When this matter was before the CIT Appeal, CIT Appeal held that in this case the purchases were not bogus, and the same position was held by the ITAT also. ITAT categorically held that by examining the facts of the case that the assessing officer has wrongly applied section 145 subsection 3, meaning thereby that the books of the assessee is not liable to be rejected under section 145 subsection 3 in this case, and the facts of the case of McDonald Company Limited versus Commercial Tax Officer 1985 does not apply to this case. And ITAT held that on the facts and circumstances of the case, in this case, the purchases made by the assessee cannot be held to be bogus. The department moved to the High Court. The High Court said that whether the purchases are bogus or not is a question of fact and it does not involve the substantial question of law. So the High Court declined to interfere into the matter and dismissed the appeal of the department. The department moved to the Supreme Court by filing the special leave petition, and the Supreme Court also held that the decision given by the High Court is justified and there is no substantial question of law in deciding this thing, that whether the purchases are bogus or not. So the Supreme Court also dismissed the SLP of the department. At the end of this video, we can say that whether the purchases are bogus or not is a question of fact and it does not involve substantial question of law until and unless there is some misunderstanding about the facts or the facts have been misapplied. At the end of this video, once again, I am repeating the name of the case. The name of the case is Joint Commissioner of Income Tax versus BHILAI Engineering Corporation Limited, and this case has been reported in 454 ITR at page number 540. The matter has been decided by Supreme Court and the date of the judgment is 1st May 2023. Thank you, friends.